First, 21st,
So, you're referencing this,
the disposal order. Yeah.
what's the question?
Was Mr. Newman involved in creating that document?
I believe that to be the case, because he gave it,
All right.
I don't know.
And when you received this order, the dispersal order from Director Newman, did you discuss the contents therein?
No, we didn't have a discussion about it.
When did you get that order?
I don't know, but on or about May 12th or 13th, somewhere in that time frame.
All right. Now you told us May 12 or 13. You told us that you've been to that encampment 6 different occasions. Yes.
Yes.
Okay. All right. So the dates that I have are the 2nd, the 10th, the 12th, the 13th, the 14th, and then the final day of the 21st. Is that right?
Say those again, please.
You went May 2nd, which was the first time you were there, true?
No, April 9th.
April 29th. Actually, okay. When you're reviewing to refresh your memory, your report, are you reviewing a report that you created or other officers created?
Other officers.
May I approach Judge? I don't know what report he's referencing, and he's been looking at it a lot. I just want to double check and see what he's looking at. Yeah, thank you. Let's see what he's got.
What was that?
Thank you. I have that report. I know what you referenced. Okay, this is not a report that you authored. It's a compilation of other reports from other officers involved in this investigation. Is that true?
That's correct.
Okay. And it references that you've been to the site on the encampment 6 separate occasions. Is that correct?
Yeah.
All right. Now, you didn't get the directive disbursement order from Director Newman until you believe the 13th or the 12th. Is that correct?
Could have been the 11th or 12th, right around that time frame.
All right. And the encampment had been going on and on those days, on the 12th, 11th, 13th, and those in that time frame for a period of at least 2 weeks. Is that true?
Yeah.
Okay. The encampment hadn't changed in terms of tents were still there. In that entire 2-week period, is that true? The encampment still was encompassed of tents. It still included tents. Yes.
On what day?
On all those days, from the 29th when you arrived all the way to the 12th, 11th, 13th.
Yes, there were 10.
Okay. There were always issues about barricades on the outside of the encampment. Is that correct?
You used the term always.
Yeah, from the 29th, my time frame that I'm referencing in this line of questioning is from the 29th till the 13th, 10, 11, that 2-week period.
There was a particular time that a fortification and barricades around the perimeter of the encampment became a significant issue. Otherwise, I don't remember having like daily conversations about the perimeter.
Okay.
I remember being at for a day or two, something we really focused on.
Tell me that day when you were really focused on the perimeter issue.
Yeah, I don't remember.
What were you focusing on?
Well, the group in our emergency operations center.
Yeah.
Which I'm a part of, was concerned about a fortification type of system that would make it unsafe and people not to be able to get out. That had been kind of erected around the perimeter of the.
How was it erected? Using what? Describe it to me.
I never actually saw that myself. Others went out and looked at it.
Okay. So you don't have personal knowledge of that, what you're describing. Is that correct? You didn't see it yourself. You didn't see anybody barricading themselves around the encampment or creating any barriers that weren't movable by hand. Is that correct?
I do remember seeing a change. I mean, I was walking around on a daily basis, you know, the encampment from the outside, and you could see it looked more like a wall. And there were sheets, I believe, over the top of it, so you couldn't see what was underneath the sheets. But
Director Marshall, my question is real specific. You didn't know what that barricade was made of. You saw sheets, it could have been string for all you know, or a clothesline. Is that correct?
could have been a lot of different things. That's correct.
All right, very good. And the conditions of this encampment were the same from the 29th all the way to the 13th of May. Is that correct? Okay, and how had it changed in your opinion?
On a daily basis, something, you know, would change. We were able to see more and more items, and more and more tents being established. And so you could see that there was a tent, for instance, that was a supply tent. You could see that there was a library that was established. You could see there was a food eating area. You could see that there was a place to hold like classes. And then you could see all the individual tents throughout the area. You could see a temporary urinal that was put up, like a TP looking tent that was observed people using as a restroom. So all these things were not there on the first day. And then they were increasingly there as time went on.
Okay. None of those individually, a urinal is not a public safety concern to you, right?
It's not a life safety.
Okay,
Police.
it's yes or no?
No, he let him answer the question.
Okay,
Not gonna cut him off. Go ahead, sir.
But as we were in our emergency operations center and all the different components, student life that we were able to contact, it would be a concern for the university for the health and safety of the students. But yeah, so that's my stance on the urinal.
all right, okay. And you guys are looking at this as a totality of the circumstances and when you're collectively grouping and discussing this, is that right?
I'm not certain of your question.
Sure, I'm trying to get a understanding as to what the encampment consisted of in the time frame leading up to the development of this directive order. My understanding that it's been substantially the same. You're saying that it grew a little bit by adding a urinal and by adding a library and by adding a couple stands where food can be eaten. You know, those are the conditions that raise the level of concern for the university?
No, there were many more factors.
Okay, so it's a collective totality of circumstances that you guys were concerned about. Is that correct?
It's fair to say that a collective totality is something we're concerned about, yes.
All right, and in that, okay, so I'm trying to get down to what was the concern? To me, individually, a urinal is not, you've said is not a public safety concern, but could be health concern. Is that true?
Say that again.
Maybe I need to slow down.
He's already answered the question about the urinal.
All right, I'll ask about a library stand. A library stand was created, yes?
After a library. Yes.
Okay, that's not a public safety concern, correct?
There's a violation of the law, trust.
Well, we finished a little bit before two. Council Douglas, you're here with us this afternoon.
I am. My trial finished, so I'm back.
Okay, anyways, I know I finished a little bit somewhere before two, and the clerks were still working till after two. So that's the morning session. So I have no list, I have no files. So let's see if I have something.
All right. Thank you, Yana. Good afternoon.
I do have a list now. Let's see. All right. Council Marable, let's see, who do you have?
Or, I'm sorry, Yana. I have Mr. Tober, Alfonso Tober. It should be a domestic.
Yep, I see it.
violence. Okay.
Okay, I have Carla. What's your P number, Council?
62755.
Okay, so just mute yourself, and then I have Council Brown. Council
Yes,
Brown?
I have Demetrius Coleman,
Yep. Council Brown, no file, P number again,
80560.
80560. And let's see, Coleman. Is there a Coleman here? Demetrius? Okay, he's a walk-in. He's here. So. Counselor, just mute yourself. All right, so let's see. I got Ragnon, got Coyle, got Vincent, I got Douglas. Okay. It's up to you. There's only, so you can get your experience, practice, however you want to do it, whoever wants to do it.
Okay, I'll do it for you.
How many times have you done it?
A lot of times.
Okay, and how many times have the trainees done it?
I think 3.
You should let the trainee do it.
Okay.
Okay,
Go ahead.
so folks, listen, we got a person that's new, so she's learning. So go ahead, madam.
All right. Welcome to 36th District Court in the City of Detroit in the state of Michigan.
Continue.
Court is now in session with the Honorable
All right, folks,
Eshate presiding.
well, it's not how you pronounce it, but it's, let's just say Magistrate Chartea. Okay, but that's okay. But the other thing is, you tried, ma'am, Madam Court Officer. But the other thing is, folks, cell phones, put them on mute or turn them off. There's no recording, okay? If you need to talk, you can talk outside. I think that's about it. Anything else, ma'am, that you forgot to tell her?
No talking or slouching, or don't rest your arms on the back of the bench. No
Yeah.
eating or drinking or chewing gum. You may be
seated.
seated. And good afternoon, Your Honor.
Okay, so the new one is trainee, okay, maybe you should get a script. And I'm gonna put fault at your mentor, your trainer, because she should have told you all that. Or given you all that information, seeing as that you have done this so many times.
No, she was training in Washington.
Okay, but she had you today?
Because yesterday we was with Magistrate Clefairy.
Okay, so she had you today?
I said your name wrong.
Yeah, but that's okay,
So I'm
but,
sorry.
yeah, but that's okay about the name. But as to the other stuff about the cell phone, about sitting, no reading, no chewing gum and all
Oh,
that.
I know all that. I was fumbling your name because she said.
Oh, okay, so, okay,
okay.
you're taking her, you want to take the heat, not her.
Yeah.
I was just trying to give you,
No,
so,
I'm
she would take me.
I'll
Okay,
take the heat.
all right, no problem. So, but now you'll remember this.
Well, how do you pronounce your name?
It's Echartea Pisania Cervera Montoya. So, but you can just say Echartea. Echartea. Char. See, there you go. Okay.
Okay.
Not R, E.
Agitator.
Yeah, Echartea.
You said agitator. I didn't say agitator.
There you go.
Agitator. Agitator. Okay.
All right, it's close enough. It's close enough.
Thank you.
All right, let's see. Is there a Jasmine Charlton? Okay, thank you, ma'am. All right, Ms. Charlton, have you spoken to a defense counsel today?
No.
Okay, so you need to speak to a defense counsel unless you have retained counsel.
I have not.
Okay, I want you to go outside and knock on one of the doors. Not courtroom 133. There's a door next to it. Let them know you're here as a walking client.
Yes, ma'am.
Okay, and the gentleman, I shouldn't be talking to you because you have an attorney. No,
I was gonna hire him, but I'm not buying an attorney. I don't have to. This ain't.
sir, don't say
I'm talking
anything.
about it, but
Sir, don't say anything.
Yeah, I had to talk to the.
Okay, sir, don't say anything. Okay, the question is, let's see. All right, Council Brown,
Yes,
your client, Mr. Coleman, says he doesn't need an attorney.
Yeah, I mean,
Okay.
Are you still representing him or not?
If I thought I would, if he said he doesn't need an attorney, then I guess that, I'm not sure. I'm gonna have to take him on his word.
So, all right, so then you're, Council Brown, are you not representing, and I want to make sure, Mr. Coleman?
I spoke to Mr. Coleman and we had a conversation yesterday and today. It was my understanding that he was turning himself in. Now, if he has changed his mind, I haven't discussed that with him yet, but I have to take him for his word if he's saying that presently. So,
Okay, so are you withdrawing your representation?
yes.
Okay,
All right, thank you.
thank you. You're free to go. Thank you, Council Brown. Okay, all right. Mr. Coleman, you need to go outside, knock on one of the doors about speaking to one of the defense counsels. Yes, sir. Council Reagan. You need to unmute, Council Reagan.
yes, ma'am, I'm unmuted.
Okay. Now, Council Reagan, I just sent out a Demetrius Coleman. He had retained counsel. I guess he and didn't want retained counsel anymore, so retained counsel withdrew. And so I sent him out the courtroom to speak to one of your coworkers or to you.
I talked to him already. I talked to him and I talked to Ms. Charlton already.
Okay, well, we're still waiting for the files.
Okay, thank you, Yana. I didn't know they had
Thank
retained.
you. Okay, we're gonna, we pause and everything. Let's see. Well, folks, we're not on record right now, so if you wanna step outside and come back in, that's fine. But if you see a young lady or a female comes in with a bunch of files, that means that they're coming so we can start. So just take a couple minutes. Yes, Council Reagan? Council Reagan, you said you were saying something?
So
You
yeah,
unmute, sir. Yeah, Council Reagan, you did this.
I
So I
was
wasn't
stretching.
sure if you were drawing my attention or somebody else's attention.
I was stretching. That's all. I'm good. Thank you though, Your Honor. I appreciate you.
Okay, no problem.
Personal bonds for everybody. Just remember that. Okay.
In your mind, personal bonds, yes. Hey. Oh, if I didn't say it, I like that color in you.
Thank you.
Yes.
Thank you.
Miss Lisa? Okay. Do I want a piece of what?
Cake,
What kind of cake?
red velvet.
Thank you. Thank you for the offer. Appreciate it.
You
Whose birthday?
You know my Saturday, me and Melissa.
Ah.
Birthday Saturday.
Well, happy birthday.
Thank you.
Yes, the day after Valentine's Day.
Right.
Yep. Just take a seat, folks. Counselor Shy? Okay, no files. Okay, however, no, they can wait there. Is Miss Lisa back there? She just stepped out. If she's gone? Because if she's there, I just need the 2 files.
I'll let her know.
Pardon me?
I'll let her know. If I see her, I'll let her know.
Is Miss Lisa right there? Lisa?
I don't think so. I think she stepped out.
Okay,
No, I think she stepped out.
all right. All right, officers. No officers. Okay. Folks, I'm gonna have you stay seated. Let me see if I can get those 2 files. Let's see if I can get those 2 files. Watch everything. Okay.
Thank you.
You're welcome.
That's our trying. I'm gonna say, that's not, but.
She talks to us. She just hopped down.
Probably know. We don't know how long I'm going to. They can be all right. I think we just doing too much for me. What's the name? Me. Oh. Ross always trying to do some work and he's even doing somebody. He wants. Y'all gonna take it. I'm be like, Ross, go somewhere. I will tell us that he's still and they gonna like that. Like he always do it. Oh, we gotta come and do it. Like that, yeah, that's not. He had to say, earbuds and do it. It's my hearing aid. You can't be discriminating against me for my hearing aid. You're discriminating against me, and I'm deaf and I'm. So yeah, how you hear me saying that? Just that long. You just start hollering. One wrong. Who you talking to? You know, I'm keep yelling at me. I'm keep yelling at me. Yeah, you know, I'm yelling. But Donald Trump don't know what he's doing. They just keep putting that in there because they stupid. Everybody who voted for him stupid.
Coleman? Charlton?
Yes, ma'am.
Okay, you both need to be fingerprinted.
Yes, ma'am.
Okay. Sign the order. Okay. Here. Ladies, for both of these folks, they need to be fingerprinted. DDC,
Good afternoon.
yeah, DDC, I have no files yet, but you have a copy of the list?
Yes, we do.
Okay, so, DDC, just stand by. And DDC, when we start, can you bring in October Alfonso, number 5 on the list? That person has retained counsel. But that's when we start.
I'm sorry, who did you say?
Number 5 on the list, Alfonso Tober, when we start. Number 5. Last name is Tober. First name is Alfonso. Thank you.
Way back to the goal. It's a green. Oh.
All right, folks, we're going back on record. There we go. On record now. Yes, I do. Emails. Okay. EDC, can you bring Mr. Tolbert? Thank you, Miss Lisa. Sir, please say your full name.
Alfonso Jemison Tolbert Jr.
Thank you, Mr. Tolbert. I'm Magistrate Chartea. You're here on a criminal matter. Case number is 250-444-5001. Sir, you do have an attorney. Go ahead, counsel.
Thank you, Your Honor. Good afternoon. Carla Marable, P number 62755, on behalf of Mr. Tolbert.
Counsel, you wait for my reading, stand mute.
We waive formal reading and stand mute.
Thank you, ma'am. I'm going to enter plea of not guilty. Court date is February 21st, 2025. It is a pretrial in front of Judge Austin Garrett. Mr. Tolbert, let me tell you some bond conditions. 1, you're not to possess any firearms or any other dangerous weapons. 2, you're not to have any contact with complainant Deja Johnson. That means no person to person contacts or no contact with third parties, no phone calls, no emails, no text messaging. Do you understand those bond conditions, sir?
Yes.
Okay. That being said, Council Ragnan, you represent the people?
Yes, Samuel A. Ragnan, P 23-157 on behalf of the people, Your Honor. Good afternoon.
Recommendation, sir.
People are asking for $5,000 personal bond, but we're asking for a tether. Currently, if he's employed, Your Honor.
Okay. I heard a personal bond and you want a tether?
Yeah. I asked for $25,000 personal bond.
Okay.
And a tether with curfew and no contact.
Okay.
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 Very assaultive matter in front of an 11-year-old child. We've reviewed it, I'm sure, Your Honor, but they're in a hospital trying to talk to a caseworker about medical care for the 11-year-old daughter. When the caseworker walked out of the room, the defendant became irate and started cursing in front of the 11-year-old child. The complainant mother said, "Stop that, leave the room." With that, she started videotaping him. He went around the bed, knocked the phone out of her arms, and threw it on the floor, stomped on it several times to break it. The police were called. The little 11-year-old girl tried to intervene and have him to stop it, so he didn't hurt her mother, which is a terrible thing to put a child. So we believe a tether is important because of the assaultive behavior of the defendant and also in front of the child. Thank you.
If I may,
Council Reagan, are you representing Mr. Tolbert? I mean,
No.
excuse me, I'm sorry. Council Marable, I apologize. Go ahead, ma'am.
Mr. Tolbert has no prior criminal record whatsoever. He does work. We do agree with the personal bond, but I don't believe that there should be a tether involved with this. I have looked at the allegations. The allegations is not that he touched her, he hit her or anything. It's that there was a phone was dropped and broken. We asked for a personal bond, Your Honor, but not for a tether. I think that a tether would cause him to be in jail longer, is intrusive, and he does work. So we're objecting to the tether, Your Honor.
Okay, so he's going to get a $25,000 personal bond. The issue is whether or not he's going to get a tether in this particular matter. From what I'm reading, the allegations in the investigator's report is that allegedly he grabbed the complainant's arm, pushed her to keep from getting the phone. So supposedly the complainant had a phone. Looks like the complainant was trying to record, and it looks like Mr. Tolbert didn't want to be recorded.
Yeah,
Mr.
yeah.
Tolbert, Mr. Tolbert, if
Yes.
somebody's recording you, okay, even though you don't like it, you can't grab or do anything like that. Do you understand that?
Oh, yeah. That's not what
Okay,
happened.
well then just don't say, oh yeah, understand. So if
Yeah.
somebody's recording you, you can't approach them and you can't assault them or allegedly assault them or anything like that. Do you understand that?
Yes, that's not what's happened. That's not what happened. though.
Okay, Mr.
No, I
Tolbert,
didn't
just say
ask you
yes or
that,
no.
sir. Do you understand what I've told you so far?
Yes.
Okay, I don't want you to give me any explanations. I don't want you to give me the alleged allegations because that can hurt you. That's why you have an attorney. Counsel Ragnan, did you want to add something new?
Yes, the defendant admitted to smacking the phone out of the complainant's hand, Your Honor.
Okay.
Her hand was not injured, so it did drop.
All right. So,
Alleged.
so I read all the allegations. I'm not going to place them on a tether, $25,000 personal bond. However, Mr. Tolbert, I'm giving you fair warning. If you violate any of the bond conditions, next time it's going to be a monetary bond. Do you understand that?
Oh, yes.
Okay, $25,000 personal bond. You can step aside, sir.
Thank you, Your
Mr.
Honor.
Tolbert, as soon as you're released, give me a call, okay?
Okay, sure will. Thank you.
Thank
Thank you,
you.
Ms. Maribel. Have a
Thank
good day.
you.
Thank you. BDC, we can go down the list. Mr. Bernard Davis. Mr. Davis, did you talk to a defense counsel?
Yes.
Okay, okay. Mr. Davis, come on forward. Okay, sir, please say your full name. Mr. Davis, I'm Magistrate Chavez. You've been watching me while you've been sitting in court. Thank you for walking in. Your case number is 19046-14601. You have an attorney. Go ahead, counsel.
Lorraine, on behalf of Mr. Bernard Davis, waive the reading step. He's been advised of his rights, Judge.
Thank you. I'm gonna enter a plea of not guilty. Court date is February 25th, 2025. It is a pretrial in front of Judge Bryant. Mr. Davis, all right. I don't know who's doing this. Mr. Davis, let me say this. First of all, you're not to have contact with the Kamari McHenry. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand that bond condition, sir? Okay. Let's see, this is from 2019. Okay. You failed to appear prior court hearing, bond was set. Because you failed to appear, warrant was out for your arrest, bond was set at $1,000, 10%. This was from November 15, 2024. Counsel Coyle, you walked in.
Good afternoon. It looks like he posted the $100 on January 29th is what I see on the ROA.
Oh, you have more than I do. I
Right,
don't
Judge.
have an ROA. Counsel Reagan, does the Register of Actions or Counsel Coyle, Register of Actions show that he posted bond?
It's my understanding, Judge, that he did post bond. Ms. Coyle, do you have a copy of the Register of Actions? Because it's my understanding on 1/29/25, he posted $100.
That's correct. He had posted, Actions posted twice, but once it got forfeited, but he did post on the 29th of January. And so I have no objection to it being continued.
Okay. And bond is going to be continued.
Thank you, Judge. Have a great day.
Okay, thank you, sir. Bond is continued. Mr. Davis, do me a favor, take a seat, wait for your paperwork, okay? Thank you, sir. What's your name, sir?
Mary Underwood.
Is it Demerick Darnell Underwood?
Yes, Mary Underwood.
Mr. Underwood, I'm Magistrate Chavez. not only do you have a criminal matter, you're also here on misdemeanor matters. These are like traffic matters that you did not show up for court. And so what they did, the judges assigned to those cases issued warrants for your arrest. So this court is going to recall the warrant. You're going to get a personal bond. Nobody has to pay any money for you to get out of jail. The maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. You understand that? All right. First ticket is P105909. Failed to display valid driver's license, not on person, driving under a untitled vehicle. Next ticket is P16034747. Driver license suspended. Next ticket is P160620. No insurance misdemeanor, driver license suspended. Last ticket is P163733. Driver license suspended, no insurance misdemeanor. Court's going to enter a plea of not guilty. Court date is March 12, 2025. Free trial in front of Judge Kennedy. Sir, you have a right to remain silent. Anything you say orally or in writing, it can be used against you in a court of law. You also have a right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir?
Yes.
Okay, so let's go with criminal matter. Case number is 25055-82501. You have an attorney. Go ahead, counsel.
Great, on behalf of Mr. Underwood, Wade, he's been advised of.
He's been advised of his constitutional rights.
That is absolutely correct, Judge.
Thank you. I'm gonna enter a plea of not guilty. Court dates are February 20th, 2025, probable cause conference, followed by preliminary examination, February 27th, 2025. Both matters are in front of Judge Shakay. Okay, Mr. Underwood, bond conditions. 1, you're not to have any contact with the India Jones. When I say no contact, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. Further, you're not to go back to the Wisconsin's residence. Do you understand that, sir?
Yes, ma'am.
Counsel Vincent, go ahead, Esteban, please. Recommendation.
Thank you, Magistrate. Good afternoon. Good to see you again. We're going to be asking for a $20,000 cash of surety. We're going to be asking for monitorization as well. The allegations speak for themselves. They're highly assaultive. The culmination of this incident apparently was this defendant choking the complainant at 2 different points throughout this incident, all the while the complainant's children were in that vicinity, to the point where the complainant lost consciousness, falling over one of her children at one point. Now, Judge, we do feel as though this defendant is a clear and present danger to this complaining witness. But in addition to the allegations, at the time of this offense, this defendant was on a personal bond for a felony false pretenses. And the defendant ended up pleading in that case. Currently, he's on probation. But more important to this court, under 7656A, he was on a personal bond. And the court must at this point, shall, meaning must, give a cash bond. But Judge, I don't even know if that needs to be triggered because we feel as though he's a danger in and of himself for the allegations that we read here in this report. I don't know if there's any way of getting around the idea that this defendant was choked. She allegedly had visible injuries to her neck. And again, it was in front of the kid. So respectfully, Judge, asking for that.
What was the recommendation? I know you wanted GPS.
Yeah, 20,000 cash of surety.
Thank you. Counsel Reagan, go ahead, please.
Judge, my client is 30, Judge. He is on probation right now, as Mr. Benson said, for it's a non-assaultive case, Judge. My client works at General Motors every day. He has custody, full custody of his kids, Judge, that live with him, his 2 children. Now, he met this young lady on Facebook, it seems like, and they dated for about 3 weeks. And for some reason, she moved in. But what really happened, Judge, she set him up to get robbed. That's what really happened. A lot of this stuff is made up, Judge, by her. You know, when he found out her plan for her to set him up and be robbed. But you know, I'm not gonna say that's a less. You don't really, 3 weeks is not a long time. You don't let people come live with you, Judge. But regardless, I think a personal bond is in order, Judge. He doesn't have any assault type history. He doesn't really notice You know, so he's not gonna have contact with her. I think this may have been just a bad relationship decision, but he says he never choked. In fact, she says there were no injuries. In one part of the paragraph, she says kids had injuries and the victim had no injuries. That's what it says. So I'm asking for the personal bond. Just one of the things, reason I'm is that, you know, this matter just got signed today. You know, it's alleged to have happened in September, but the warrant wasn't signed until today. So, you know, that to me is when it starts, the case starts, you know, today in my eyes. That's just my eyes, Judge. So I'm asking for the personal bond with no contact with this lady. He doesn't want to have contact with her. In fact, he's trying to file police charges on her. But I'm asking the court to consider that.
Was this a case that he surrendered or not? Or he was arrested?
He was at his probation office, visiting his probation officer, and he was told that he would not be violated, is what he was told. You know, I don't know if this because it happened allegedly back in September after he pled, but he was at probation. She said, "Oh, you got an outstanding warrant," and they came and got.
Okay, question. Was he served a personal protection order?
Yes. Were you served a personal protection order?
Yes.
When? Council Reagan?
When?
I got it yesterday.
Yesterday? So
Okay.
Let me change that. Let me change that around, because if the warrant was just signed today, when you were arrested at your probation department, is that what you said?
Yes, I got arrested Monday at my probation.
Monday. So the warrant had not been signed as of yet, Judge, because it looks like it was just signed today. So he was arrested Monday. So let me be clear. Arrested Monday, brought to DDC, warrant been signed today. So I just want to be clear.
All right, so I don't see an issue of flight, because he did go to his probation office. Okay, that's where he was arrested, and he was served with a personal protection order after this incident occurred. Is that correct, Council Reagan?
Judge, that is absolutely correct. After the allegation.
Okay.
That's correct.
That's all I need to know. This happened from September 2024. Council Vincent, has there been anything new?
Per the APA notes, yes. He's called and he's harassed her multiple times. Not just that, though. That PPO was filed shortly after this incident. It was filed with the court. He was served with it. Just a
He was
couple.
served with it supposedly just after this he was served with that just this year, but the incident happened September 2024.
Yeah.
What I want to know is, you said per the APA's notes that there was threats made?
Yeah, apparently the defendant's been harassing the complaining witness. It was, I'm sorry.
When?
I can pull it out.
Bless you.
I don't have an exact date when. I have a notation. I have a notation in, this is just yesterday, that the assigned prosecutor had just spoke with the complaining witness, and that she is in possession of photos of bruising around her neck from the choking, and that she is very anxious and fearful of this defendant. But
When did that conversation occur?
Yesterday.
Okay, so my question is was there anything in terms of Okay, threats made recently, since September of last year.
Yeah, I don't have the date because I go through these entire files, so it wasn't, I gotta,
Okay. All right. Because what I have here is in the investigator's report, but this was on September 7, 2024, in which supposedly the defendant had been calling the complainant's phone, making threats to kill her. That is from September 2024. Court uses clear and convincing evidence standard when it's considering entertaining monetary bond. The court is, but we started off with personal bond basis. He's on probation. It's not assaultive. He went to his probation officer's office. So I'm not seeing a flight risk. The only issue is danger. All right. Court's heard enough, read the allegations, in which supposedly there was allegations of strangling and there was threats by phone to kill her. Court is satisfied there's enough that he is in danger. Mr. Underwood, in this particular matter, there is going to be a monetary bond. There's also going to be a GPS tether. Counsel, you said that he works, Counsel Reagan?
That's correct, Judge. He works at General Motors.
Okay.
Yes, yes.
So he's going to be work only, GPS tether.
Ma'am, I do have to get my kids to school and also
You're going to need somebody else to help you, sir. Because right now, I am going to give you GPS tether work only. What I also want to know is, Counsel Vincent, you did say monetary bond, cash surety, was that the 20?
20,000. Yes, Magistrate.
20,000? Okay. Okay, but what I don't have is that the last time he made, this court is finding Mr. Underwood a danger. Instead of a cash surety, it's going to be a $20,000, 10% with a GPS tether. And Counsel Reagan, is this unaffordable?
It is unaffordable, Your Honor.
Okay. Okay. All right. Just so you understand, Mr. Underwood, this court is not the last word, even though the bond is $20,000, 10%. It's unaffordable per your attorney. You're going to get another court date this Friday, February 14th, 9 o'clock in front of Judge McConnell, who will look at your bond amount and bond conditions. Do you understand that, sir?
I have one question. So does that 10% of 25, what's that?
That's $2,000.
Okay.
Yeah, Judge.
Okay.
It's unaffordable, Judge. And the only reason, Your Honor, I'm asking the court to reconsider, the only reason is because of the offense date allegedly of 9/6.
Yep, that's why, Counsel Reagan, instead of making it a cash surety, I made it 10%. I still believe that your client is a danger, but balancing that out, GPS tether, $20,000, 10%. Thank you. Anything else either of the counsels want to put on the record?
Where do they go pay that at?
No, Your Honor. They'll
Okay.
instruct you over there. They'll instruct you.
That'd be at the jail, sir, I believe. Okay. Who's next?
Oh.
Okay, right there. Say your name.
Rodriguez Hicks.
Rodriguez Jamel Hicks, sir?
Yes.
Mr. Hicks, I'm magistrate at Troutdale, sir. Not only you here on a criminal matter, but you're also here on some misdemeanor matters. These are misdemeanor matters that you did not show up for court, so we're going to recall the warrants. You're going to get a personal bond. Nobody has to pay any money for you to get out of jail. The maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. Do you understand what I just said so far? Thank you, sir. Ticket number is P 1438526. Count 1 is no insurance misdemeanor. Count 2 is drama license not valid or improper license. Count 3 is reckless driving. That enter plea of not guilty. Court date is.
I went to court for that already. I went to 36th district for that.
When?
I went to the 36th district for that.
When?
Like last year or 2 years ago.
Okay. Well, sir, I'm not sure if these are, but I'm gonna give you a court date. You are getting a personal bond. Go to court, figure out how this matter is dealt with. So it is March 14, 2025. In front of Judge Millhouse. Again, you're getting a personal bond pre-trial. All right, Mr. Hicks, you have a right to remain silent. Anything you say, orally or writing, it could be used against you in a court of law. Also, right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir?
Yes.
Okay, so criminal matter, case number is 25055-83501, sir. Go ahead, Counsel Reagan.
Great, on behalf of Mr. Hicks, way to read and stand mute, he's been advised of his rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are February 21st, 2025. It is a probable cause conference, followed by preliminary examination, February 28th, 2025. Both matters are in front of Judge Jefferson. Mr. Hicks, while this case is pending, you're not to go back to the gas station located on East 7 Mile. Do you understand that, sir?
Yes.
Okay. All right. Counsel Douglas, go ahead, please.
Jennifer Douglas for the people, P72748. Your Honor, Mr. Hicks, the people don't have an objection to a 10,000 personal. I am asking for a teller to ensure no contact. Our concern about Mr. Hicks returning is based on the owner's statement to police that Mr. Hicks frequently visits the location and harasses the staff. And Your Honor, the report indicates that Mr. Hicks continued to make threats about the gas station, even when officers had taken him into custody. So we do have concerns about him returning based on that, and that's why I'm asking for a tether for safety of the staff. But other than that, I don't have an objection to 10,000 personal.
Okay. Counsel Reagan, no objection to the personal?
No, Your Honor.
Okay.
Would object to the tether, though.
Okay, you object to the tether? Well, the court read the allegations in this particular matter. And it looks like this was February 10th, a few days ago. Police arrested Mr. Hicks, was very irate, was making threats towards the gas station. Supposedly that there is a video showing Mr. Hicks destroying the inside of the store. Let's see what else. And it also says that Mr. Hicks always comes to the station. So Mr. Hicks, I'm going to give you a $10,000 personal bond. I'll place you on a GPS tether. Counsel, does he work or not?
No.
He doesn't work, Judge. I'd ask for no tether. He never had a case before to have him stay away from him. So it's like he has no criminal history, Judge. So if you tell him to have no contact, then that would be the condition. If he violates that, then that would be something you would deal with. I just don't think a tether, is necessary in this case for non-assault.
Okay. Well, the court finds otherwise because still goes to that location, makes threats as the police are there. He's making threats against the gas station. And that would also include the personnel.
Do you believe everything you read in that write-up, every single word?
Okay. All right, Counsel Reagan, you want to place anything else on the record?
That is all, Judge. Thank you very much for your consideration.
No problem. So $10,000 personal bond, GPS tether, house arrest, and Mr. Hicks, just so you know, your attorney of record, whoever that person is, can approach Judge Jefferson about removing the GPS tether. Thank you, sir. That concludes your arraignment. What's your name, sir?
Davon Sills.
I'm sorry, say that again?
Davon Sills.
That's
Seals.
co-defending case.
Davon Sills.
Yep, that's
Okay.
Mr. Parham Jenkins and Mr. Sills, Judge, you see there.
All right, Mr. Sales, raise your right hand, please. Thank you, Mr. Sales. I'm Magistrate Chartester. Put your hand down. Sir, not only do you have a criminal matter, but you also have some misdemeanor matters. And the gentleman to your right, what's your name, sir?
Juan Parham Jenkins.
Okay, Mr. Parham Jenkins, you are defendant two in this case. Okay, you also, your co-defendants on the criminal matter, you both have misdemeanor matters. These misdemeanor matters, the court is going to recall the warrants. You're gonna get personal bonds on those misdemeanor matters. The maximum penalty on each misdemeanor matter is up to 93 days jail and or $500 fine. Let's go with Mr. Sills first. Mr. Sills, you understand everything that I've said so far, sir?
Yes, but I have a lot of questions.
Okay, all right, so let me get through this. And then if you want to ask some questions, not about the alleged facts or anything like that, I will help you out, try to. First ticket, and it's only one ticket. It is P1616386. A driver's license never acquired, no insurance misdemeanor. An enter plea of not guilty. Court date is March 13, 2025, pre-trial in front of Judge Archer. Did you understand so far everything that I've said?
Yes, ma'am.
Okay, did you have any questions about these misdemeanor matters?
Yes, it was some statements that were in there that was not even eligible in the case.
Okay, well, see, that's gonna be something that you, okay, sir, Mr. Sills.
A driver's license, that's the misdemeanor?
That's what I'm talking about, your traffic matters. That's
Yes,
something
ma'am.
that you can talk to your attorney, okay?
Yes, ma'am.
Okay, so, and Mr. Parham Jenkins.
Yes, ma'am.
So far, everything that I've said to Mr. Sills, except for the traffic matters, it applies. About, you're gonna get a personal bond, the maximum penalty on the traffic matters is up to 93 days jail and or $500 fine. You understand what I've said so far?
Yes, ma'am.
Okay, the first ticket is 255342, no operator's license, no insurance misdemeanor. If that's it, let's see if that's, yeah, that's it. Okay, so you're gonna get a personal bond. You're gonna enter a plea of not guilty. Court date for you is March 12th, 2025. It is a pretrial in front of Judge Ramsey Heath. Sir, and for both of you gentlemen, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during any questioning. Mr. Sills, you understand the rights?
Yes, ma'am.
Mr. Parham Jenkins, you understand the rights?
Yes, ma'am.
Okay, all right, so that concludes your traffic matters. Now let's go over your criminal matter. All right, case number is 250-5583401. Mr. Sills, please say your full name.
Darnell Sills.
Okay, thank you. Mr. Parham Jenkins, please say your full name.
Juan Deshaun Parham Jenkins.
Okay, Mr. Sills, you are defendant one in this case, and Mr. Parham Jenkins, you are defendant two in this case. Gentlemen, you have the same attorney, Counsel Reagan.
Reagan, on behalf of Mr. Parham Jenkins, and Mr. Sills, Judge, waive the reading as to both gentlemen. They both been advised of their rights.
Thank you. Gentlemen, for each of you, you have the same court date, which is February 20th, 2025, probable cause conference, followed by preliminary examination, February 26th, 2025. Both matters are in front of Judge Giles. And let me see. Okay. The charges are from February. They're not assaultive. Counsel Ragnan, go ahead, ask Mr. Sills, please.
As Mr. Sills, you're asking for a $25,000 personal bond, Your Honor. This incident happened when they came to the gas station in their vehicle, both defendants. Mr. in the store, he came back out of the store. Mr. Parham Jenkins told him to go get that. Mr. Mr. Parham Jenkins moved the vehicle, and then they were walking away. And now, Mr. Sills has no record that I'm aware of. Mr. Parham Jenkins, if I may finish, Your Honor, has 4 felony convictions, 7215 B&E, 51822 CCW, 51822 weapons, firearm possession by a felon. And he also has a 4th one. He was convicted of police assault, resisting and obstructing. 2 other charges for the same thing were dismissed in a plea bargain on 12/16/22, and he was discharged from probation on 11/19/24. So I'm asking for a $50,000 personal bond for Mr. Jenkins and a tether with curfew. Thank you.
All right, Council Reagan, first of all, on Mr. Sills, any objection to $25,000 personal bond?
Oh, yeah.
Okay, and I don't believe there was any GPS tether. Is that correct, Council Reagan? I mean, Council Ragnan?
Yes, correct. He was cooperative.
Okay. All right, thank you. And Mr. Parham Jenkins, Council Reagan, any objection to the $50,000 personal bond?
No objection.
Okay, but you object to the tethering, correct?
Absolutely, Judge. These are non-assaultive matters. Tethers, I believe, are put in place to maybe keep someone away from someone in the immediate danger to that person. But I don't think that Mr. Parham Jenkins is a flight risk per se. I think, he's going to come to court. He has 5 kids here locally, Judge. He has ties. I don't think a tether is necessary in this particular case, Judge. Understanding he does have priors. I do understand that.
Council Ragnan, was there anything that he has to keep his history? Failed to appear?
I did not get a chance.
Don't
to
have
go through
anything?
the case. No, Your Honor. I don't know.
All right, so don't have anything like that. So it's gonna be a $50,000 personal bond. Gentlemen, you both have personal bonds. However, you don't show up for court without a reasonable explanation, you violate any of the bond conditions, the next time you're gonna be looking at a monetary bond. You understand that, Mr. Sills?
Yes, ma'am.
Understand that, Mr. Parham Jenkins?
Yes, ma'am.
Okay, that concludes your matters, gentlemen. You can step aside.
Thank you, Your Honor. Thank you, Mr. Reagan.
Thank you.
Next guy.
Jalen Robinson.
Mr. Robinson, this magistrate at Chartea. Your criminal matter is 250-558-3801. You have an attorney. Council Reagan, you waive formal reading, stand you?
I do.
Okay, thank you.
No.
Can enter plea of not guilty. Court dates are February 19, 2025, probable cause conference, followed by preliminary examination, February 26, 2025. Both matters are in front of Judge Robbins. Mr. Robinson, while this case is pending, no firearms or any other dangerous weapons. You understand that, sir?
Yes, ma'am. Yes, ma'am.
Council Douglas, go ahead as to your bond recommendation, ma'am.
Your Honor, the people aren't going to object to a $35,000 personal bond. We do have some concerns given that Mr. Robinson is accused of fleeing on foot, but this is non-assaultive. While he does have some criminal record, it's been some time. It's been several years since he's been in trouble. So, Your Honor, the people won't object to $35,000 personal.
Okay. No objection?
Yes.
Okay.
No objection, Judge.
Council Reagan is not objecting. So, sir, you're going to get a $35,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that?
I'm sorry, can you repeat that? They were walking out.
Your bond is $35,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that?
Yes, yes. And you said the court date was.
Okay. Sure. February 19th and February 26th, both matters are in front of Judge Robbins.
Okay.
Okay? Go to court, handle your matter, sir. You can step aside. DDC, is that all for males?
Yes, ma'am.
All right, thank you. You'll give me a few minutes and then you can call in for the female side.
Yes.
Thank you, DDC. All right. Let's do Coleman and Charlton. Please step forward. All right. Gentlemen, what's your full name, sir?
Demetrius Lozano Coleman.
Okay. All right. And your name, ma'am?
Jasmine Janae Charlton.
Okay. Ms. Charlton, you are defendant one in this case. Mr. Coleman, you are defendant two. Case number is 250-55631. Counsel Reagan, go ahead, please.
So Reagan, on behalf of Ms. Jasmine Charlton, Your Honor, Mr. Demetrius Coleman, as to both individuals.
Counsel,
Yes,
you're
Your Honor.
coming in, at least from my perspective, choppy. You wait for Marina and stand mute. Is that a yes?
Yes.
Thank you. I'm gonna enter a plea of not guilty for both defendants. Excuse me. Court dates, please listen. February 25th, 2025. It is your probable cause conference, followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Taylor here in 36th District Court. Okay? Ms. Charlton? Okay, all right. Now, let me tell you, both of you, you're not to have contact with let's see, Isaiah Watkins and let's see who else.
We have an open.
Ma'am?
Hold on.
Don't say anything. Don't say anything. No contact with Isaiah Watkins. Let me see. They also have another name of Sabrina McCaw. Let me see that. Okay. No contact with Sabrina McCaw, MCCAA. You understand that, Ms. Charlton?
Yes, ma'am.
Understand that, Mr. Coleman? When I say no contact, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Understand that, ma'am? Understand that, sir? Okay. You're not to possess any firearms or any other dangerous weapons. That includes pepper sprays, that includes brass knuckles, and that includes tasers. Understand that, ma'am?
Yes, ma'am.
Understand that, Mr. Coleman? Okay. And let's see, this allegedly occurred at a web. Neither of you to go back to that web location. Understand that, ma'am?
Yes, ma'am.
Understand that, sir? Okay, so, all right, so I don't have any issue about flight. Both of them walked in. Counsel Douglas. So go ahead as to bond recommendation, ma'am.
Your Honor, Ms. Charlton, the people wouldn't object to a 75,000 personal bond, but we would be asking for Tyler with the curfew. On Mr. Coleman, we're asking for a bond of 10,000 cash as surety with Tyler and a curfew. We're not arguing flight, we're arguing dangerousness. Your Honor, here we have the allegations. I know the court's had a chance to look at the report. Our concern here is that this is supposed to have happened in the presence of multiple children, that this seems to indicate an inability or a refusal to control anger, since the anger seems to have been directed specifically at a particular child. Your Honor, with Christmas presents being stolen back, Ms. Charlton allegedly punching a television she had gifted the children. And so, Your Honor, we do have concerns here for these kids. Your Honor, the police didn't just speak to their mother, they also spoke to the one child who's supposed to be the one who opened the door to find out what happened. And so it's not just the mom saying this happened, there's also the one child saying that this happened. Your Honor, we know that there is a file note from January 31st of this year, indicating that the complaining witness told the prosecutor's office that both Ms. Charlton and Mr. Coleman had been back over to her house, and that Mr. Coleman had shown a firearm when they went back to her house. It doesn't indicate a date, but it indicates that the complaining witness was waiting for a detective to call her back, which would suggest that it was after this date of this incident. And so, Your Honor, we do have concerns. Mr. Coleman has prior convictions, which you can see in the HAB notice. And while they're older, they are concerning in that one is the 2009 CCW. It says 2011 home invasion second. What's missing is there was a conspiracy charge that went along with the home invasion second, Your Honor. And so we do have concerns for these children. There's not an allegation that there was physical danger meted out to the children, but that their items were stolen, their television punched to break it so that they couldn't watch it while these children were present. And so we do have concerns about this situation. That's why I'm asking for Ms. Charlton, 75,000 personal with tether and a curfew to ensure no contact. For Mr. Coleman, asking for 10,000 cash as surety, tether and a curfew to ensure no contact.
All right, so let's go with Ms. Charlton. After this allegedly happened, December 29, 2024, has there been any contact or been any threats made?
The file note says that the complaining witness said on January 31st that they had been back to her house.
Did it say when they
That
were
they
back
had
at
been,
the house?
no, it just said that they had been to her house and that Mr. Coleman showed a gun.
Showed a gun. Was
Yes,
there
ma'am.
anything to indicate that there were any threats made while he showed a
It
gun?
didn't say threats.
Okay,
It said showed a
so he
gun.
just showed a gun. Did it say anything about Ms. Charlton making any threats
It did not, Your Honor.
towards either anybody?
No, Your Honor, just said she had come to the house with Mr.
Okay,
Coleman.
well, first of all, even though this allegedly occurred on on December 29, 2024, there were no bond conditions set. There was no criminal case. The criminal case was just done on February 3rd. It was signed. Probable cause hearing was heard, and it was done and signed. So, Ms. Charlton, you're going to get a personal bond. And Council Douglas, what I want to know, and Council, hold on, first of all, Council Reagan, any objection to the personal bond?
No.
Okay, and what I want to know is, there is no KPS history in regarding to Ms. Charlton, is that correct, Council Douglas?
She doesn't have any criminal history.
Okay, so $75,000 personal bond. Ma'am, if you violate, listen, if you violate any of the bonds, no, if you violate, understand. I'm gonna give you an opportunity to say something, okay? If you violate any of the bond conditions without a reasonable explanation, you're gonna be sitting in jail, and I suggest you bring a toothbrush. Now, do you understand what I've said so far? Now, you have the right to say something, okay? And you can say something. However, if you do, you see a little red thing, I don't know. Yes, you see it right there, that's red? That means everything is being recorded. That means that whatever you say, okay, can be used against you, whatever you say. Do you understand that?
Yes, ma'am.
Okay, now, did you want to say something?
Yes, ma'am.
Hold on, Council Reagan.
I don't want her, she doesn't need to say anything right now. We have a personal bond. It doesn't get any better than that. Doesn't get any better.
Listen to your attorney.
Hold on, just wait. Wait, that's it. Okay, thank you, Judge. Let's, can we keep?
Okay, all right, your attorney is saying for you not to say anything. He's recommending that. Do you understand that?
Still want to speak.
Okay, all right, you want to talk about the alleged facts? It's either yes or no. Then no.
Yeah, we're not.
Okay, because if you do, Council Reagan, let me finish. If you do, ma'am, and that influences me, okay, you may be going to jail.
I just wait.
So right now you got a personal bond. The question is whether or not you should get a tether on you. At this point, I don't see so. I don't see a reason. Now, is there something that you want to say as to the conditions?
No,
Is there something that you want to say as to the bond amount?
no,
Is there something that you want to say as to the court dates?
no.
Okay. With that being said, Council Reagan, you want to come in person?
Well, no, Judge, we're fine. I just wanted, let's move, can we move to Mr. Coleman? Because I'm gonna make some.
Okay, we're still on Miss Charlton.
Okay, I'm
Miss
sorry.
Charlton. Okay. Now, I know you really want to say something. Is that
Yes.
correct?
I'm gonna say it.
Okay, but hold on, but you want to say something, but the court is suggesting to you, your attorney has suggested to you not to say anything. Do you understand that?
Yes.
Wants to
Okay.
talk about an active PPO that she has against the complaint. She has a PPO.
Okay, and that's fine. That may or may not be, but that's not with this case. If you have an active PPO, let me just say this. If you have one against the complaint has an order against her that she's not to have any contact with you. But you're under this case, not to have any contact with her. Do you understand that,
Yes,
ma'am?
ma'am.
Okay. Now, anything else that you wanted the court to know?
No, ma'am.
Okay, thank you. $75,000 personal bond. I'm not gonna put a GPS tether. Violate, ma'am, bring a toothbrush. Do you understand that?
Yes, ma'am.
Okay, now, let's go to Mr. Coleman. And Council Douglas, you
Yes,
said
ma'am.
personal or monetary?
For Mr. Coleman, I asked for 10,000 cash as surety with tether and a curfew.
Okay, again, same thing, okay? He was over there. He had a gun. Was there anything other than supposedly that he showed that he had a gun? Was there anything about any threats were being made? Any threats were being implied?
That's all the note said, is that they went to the house and he showed a gun. That's all it says.
Okay. Council Reagan, you wanted to say something as to Mr. Coleman?
Yeah, I'm sorry, Judge. I thought we were talking about the case, because I didn't get done as it was an unarmed robbery charge. But just to address that, Judge, and I think Ms. Douglas, was kind of clear about it, and I think it kind of was concerning to the court maybe that on January 31st, I guess this is what the prosecutor's note said. But it's concerning that the young lady doesn't say exactly when this happened with the gun, when he came to the house with the gun. And that to me, that's easy to say that he came to my house on XYZ date with a gun, but that's not in the note. The note in Ms. Douglas says on the 31st he came with a gun. And I think that's very telling too, Judge. I mean, that's it should be more complete. I would think, Judge.
I think that the note should be more complete. I don't know what was actually said. The note.
Right, Ms. Douglas. Right. The note should be more complete. Yeah.
Okay. However, Mr. Coleman, okay, you have prior convictions.
Yes.
You're not even supposed to be near a gun. Okay, so I don't want you saying anything. So I'm gonna give you a chance. I'm gonna give you $100,000 personal bond. However, sir, personal bond, nobody has to pay you money for you to get out of jail. However, if I hear, sir, that you violate the bond conditions, bring a toothbrush, because you're gonna be sitting in jail because there's gonna be a monetary bond. Do you understand that?
Yes, sir.
Okay, so do me a favor, take a seat, wait for your paperwork. Folks, anything else you want to put on record?
Nothing from the people. Thank you, Your Honor.
Thank you. All right. I believe we're done with males and we're going to the females.
All right.
All right, DDC, who's first?
Yes, this is Miss
Shamir Marley Morris.
I'm sorry, say your name again, ma'am.
Shamir Marley Morris.
Is it Shamir Shante? Marlon Boris, ma'am?
Yes.
This Marlon Morris, this magistrate at Chartea. Not only do you have a criminal matter, but you also have misdemeanor matters. These are misdemeanor matters that you did not show up for court. We're going to recall the warrant. You're going to get a personal bond. Nobody has to pay any money for you to get out of jail. The maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. You understand that, ma'am?
Yes.
All right, let me tell you what they are. First ticket is P337638. Count 1 is driving under a child title vehicle. Count 2 is no insurance misdemeanor. Count 3 is failure to display valid operator's license, not on person. Next ticket is P511200. Failed to display valid operator's license, not on person, driving under a child title vehicle, no insurance misdemeanor. Next ticket is P511200. Failed to display valid operator's license, not on person, driving under a child title vehicle, no insurance misdemeanor. Next one is P511200. I already said that. Next one is U 594-60121. Loud noise. Beyond after the, we're supposed, beyond 10 o'clock, neighbor complaining. Next one is 10518955, no officer's license on person, no insurance motor vehicle. Next one is, let's see if that's same one. Yep, that is. And the last one is 14425414. Driveway license not valid. Going to enter plea of not guilty. Court date is March 13, 2025. Pre-trial in front of Judge Wagner. Okay, Ms. Marlon Voris, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, ma'am?
Yes.
Okay, let me start off with the criminal matter. Case number 2505583-101. You have an attorney. Go ahead, Counsel Reagan.
Mr. Philip Reagan on behalf of Ms. Shamir Marlon Morris, Your Honor, as to the arraignment, we would waive the formal reading, stand mute. She has been advised of her right.
Thank you. I'm going to enter plea of not guilty. Court dates are February 25th, 2025. It is a probable cause conference followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Taylor. Ms. Marlon Voris, let me give you some bond conditions. One, you're not to have any contact with Leanna Armin. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You are not to possess any firearms, other dangerous weapons like pepper sprays, tasers, knives, brass knuckles, and you're not to go back to, it looks like, the Stringham Court residence. Do you understand those bond conditions, ma'am?
Yes.
Thank you. All right, Counsel Vincent, go ahead as to bond, please.
Thank you, Magistrate. Steve Vincent, P71917. We're going to be asking for 150,000 cash as surety. Judge, we have competing stories here between the complainant and the defendant. However, unfortunately, we have a witness that pushes back towards the defendant's rendition of what happened. The complainant here ends up telling police that this defendant, after an argument, ended up stabbing her, holding a 6-inch knife in an overhand type position. The defendant here states that the complainant ran into the knife, and that's how she ended up getting stabbed. We have a witness who didn't see the stabbing, but heard the two individuals allegedly fight prior to this incident. Subsequent to the stabbing, it's the people's understanding that it wasn't the defendant who ended up calling the police, but it was the complainant running from the home, seeking some type of refuge from a neighboring house, where then the police were called. Just on its face, it's highly assaultive. On its face, it makes more sense regarding the complainant and her rendition of what happened here. She was actually intubated at the time that she ended up giving her statement to the police. Judge, all indications are that she is still in critical condition here as a direct result. To have a 6-inch blade accidentally or going into your body, or to walk into a blade, is something that I don't know of too many people who would do. With the fighting that the witness ended up hearing, with the fact that it was not this defendant who ended up calling the police, the people feel as though that this is something, unfortunately, that causes great concern, that poses a danger to, at the very least, the complaining witness. She's still in the hospital. So we're asking, the lead charge being an AWIM, we're asking for that high cash bond.
All right, Counsel Reagan.
Yeah, Judge, just briefly, this is one I thought, I looked at the charge initially and I said, oh my God, we got an AWIM. This is when I read it and talked, I thought that maybe the people would see a little bit differently about what happened. But you have two individuals, Judge, that were drinking together. They were both drinking heavily. And it says that report all day, not just the defendant, the complaint. They were both drinking heavily. There was no intent here, Judge. They were both there. The complaint was my client's god sister. There was no argument. There was no fight. They were drinking. They were both drunk. My client they were in the kitchen, and the complainant accidentally walked into the knife. My client was on the scene when the police came. He was right there with the complainant, trying to help her and apply pressure. Now, the complainant initially, everybody was drunk, Judge. She was in shock. She ran out the house. She was running next door. Now it's interesting. There was a person there, Judge, that didn't see anything. I don't have the information, Judge, and I don't have any of that information, Judge. I just talked to my client. She didn't even talk to the complaining witness since she's been in the hospital. When my client's at the DDC, the complainant wants my client to come to the hospital and see her. That's how that's how much of an accident this really was. Nobody feels worse about what happened than my client who's sitting in the DDC right now, Judge. And understanding that alcohol, and we talked about this, and both parties were extremely drunk. When you start drinking all day, now it's different when you're drinking an hour. You drink all day, that's some serious intoxication, Judge. Nothing intentional. It was not an intentional stabbing. Judge, and I'm asking, for and this is unusual, I'm asking for a personal bond. When I first saw the charge, I said, oh, it's an A-win. Once I read it, and once I talked to my client and kind of put everything together and heard everything, then I said, okay, well, I get it now. I'm not justifying the drinking and all that, but I get what happened. Nothing intentional, no fight, Judge. So I'm asking the court to consider a personal bond in this matter.
Okay, thank you. For the representations of both sides, court uses clear and convincing evidence standard when it's entertaining monetary bond. The court did read the allegations. So Ms. Marlon Boris, there's no drinking of any alcoholic beverages. You understand that, ma'am?
Yes.
Okay. And as to whether or not it's intentional or not, counsel for both counsels, that's a trial issue. Okay. And I do see that in the allegations is that both were drinking and that allegedly the complainant supposedly approached her in an animated manner, fashion, and then she ran into the knife.
That's what the defendant ended up, naturally, that's what the defendant ended up telling. And then if you go further, we have the complainant's rendition of what ended up happening. So that's why I premised it by saying there are two competing ways that this end, but that's why the individual that heard the two of them fighting prior to, and then ironically, we have a stabbing afterwards.
Yep. Okay.
That's why the people had asked for what they asked for, that it's more than possibly what is being represented by defense counsel and the defendant.
I just would like for it to be in the investigator's report. I want that part that Mr. Benson references about what the complaint, her statement, that I would think that would be in the report in a big way.
It is. Read it. Last paragraph.
Folks, I've heard the representations.
He's
both sides.
saying
folks,
that it should
that's
be,
it.
but it is. Read it.
Counsel, stop. I've heard enough. I think everybody has a copy of the investigator's report. Okay, I've heard the allegations, and yes, supposedly that third party said that both complainant and defendant were arguing, and then supposedly that there is a stabbing. The witness did not see the stabbing. The defendant was there. The complainant left that location, went to another location, neighboring apartment for help. So as to whether or not this is intentional, that's a trial court issue. But in this particular matter, I believe the recommendation was cash surety. Is that correct, Counsel Reagan? Counsel Vincent?
That's correct, Magistrate.
What was the amount?
150.
And she has no priors, correct?
I have, no, correct. I have an FA and A and B that were dismissed at exam in 2020.
Does it say who the complainant is?
I don't have the complaint on that case, no.
Okay, all right. In this particular matter, court's gonna go with $100,000 cash surety. Council Reagan, that's unaffordable, is that correct?
That is unaffordable, Judge. And
Okay.
I apologize. But I just don't see that in the last paragraph. Unless I just don't have it.
Okay, that's, so because it's unaffordable, Ms. Marlon Boris, you're gonna get another court date this Friday, February 14, 2025, 9 o'clock in front of Judge McConigal, who's gonna look at the bond amount and bond conditions. Do you understand that, ma'am?
No.
Let me repeat that then. Your bond is $100,000 cash surety. Your attorney has told me that it's unaffordable, that nobody can pay $100,000 cash or the equivalent in surety. So you're gonna get another court date for this Friday in front of another judge who's gonna look at the bond amount and bond conditions. Do you understand that, Ms. Marlon Boris?
Yes.
Okay, that concludes your arraignment, ma'am. Thank you.
Thank you, Judge.
Ms. Montgomery.
Ma'am, what's your name?
Shania Montgomery.
DDC, can we lower the camera? Because I can barely see Ms. Montgomery's face. I can just see the top of her head. Okay, thank you. I can see the whole of her head. Thank you.
You're welcome.
Is Shania Montgomery, ma'am?
Yes, Shania Montgomery.
Thank you, ma'am. This magistrate attorney there, your case number is 22045-46902. You are defendant two in this case, ma'am. You have an attorney. Go ahead, counsel.
Celebrating on behalf of Montgomery, Your Honor, waive the reading stand mute, been advised of a rights, Judge.
Thank you. I'm gonna enter plea of not guilty. Court date is February 25th, 2025, pre-trial in front of Judge Bryant. Mr. Montgomery, while this case is pending, you're not to have any contact with the Lamar Wright. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to go back to the Auburn location, and you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes.
And on January 9, 2024, a warrant was issued for your arrest. You did not show up for court. Bond was set at $1,000, 10%. Counsel Coyle.
Your Honor, generally, she didn't show up recently for her court hearing, but I have no objection to a personal in this matter, even though she has two failures to appear, based on the fact the co-defendant's case was dismissed back in December of 23 because the complainant failed to appear. So I have no objection to a personal, Your Honor.
Okay.
No objection, Your Honor.
Okay. Ma'am, you're gonna get a $10,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that, Ms. Montgomery?
Yes. Yes.
Okay. And Ms. Montgomery, I arraigned you last time and I told you that if you didn't have a reasonable expectation, that more than likely you would get a monetary bond. You were going to get a monetary bond. However, everybody is giving you another chance. So I'm going to take that and give you another chance. Nobody has to pay money for you to get out of jail. So please take that and finish, go to court and handle your matter. You understand that, ma'am?
Yes, thank you.
Thank you. You can step aside. What's your name, ma'am?
Angelica Peters.
Angelica Authorия Peters, ma'am?
Angelica Arthea Peters, yes, ma'am.
Thank you, ma'am. Ma'am, I'm Magistrate Chartea. Not only do you have criminal matter, but you also have misdemeanor matters where you did not show up for court. These are traffic matters. So we're going to recall the warrants. You're going to get a personal bond. Nobody has to pay any money for you to get out of jail. And the maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. Understand everything I've said so far?
No, can you please explain that to me again?
Sure. You have traffic matters. Traffic matters like driving without a valid license, maybe
Yes,
driving
ma'am.
an unregistered, untitled motor vehicle, maybe no insurance misdemeanor. You don't go to court. They, especially if you get misdemeanors, they issue a warrant for your arrest. Now, so far, have you heard what I've said in terms of
Yes,
that?
ma'am.
Okay,
Yes,
so
ma'am.
you're getting a personal bond. Nobody's gonna have to pay any money for you to get out of jail on these traffic matters. I'm gonna tell you what they are. The maximum penalty is up to 93 days jail and or $500 fine. Do you understand that?
Yes, ma'am.
Okay, let me tell you what the misdemeanor matters are. P 125-0158, driving unregistered untitled vehicle. Next ticket is P 125-0172, driving while unlicensed. Next ticket is P 125-1458, drive while license suspended. Next ticket is P 125-6691, driving unregistered untitled vehicle, no insurance misdemeanor, drive while license not valid or improper license. Next ticket is P 125-6705, open alcohol motor vehicle driver. Next ticket is P 128-2930, driving while license suspended, driving unregistered untitled vehicle, no insurance misdemeanor. Ticket number is P 128-6033, driving while license suspended, driving unregistered untitled vehicle. Next ticket is P 132-1190, driver's license never acquired. Next ticket is P 856431, driving while license suspended. Last ticket is X 3898192. No operator's license. Going to enter plea of not guilty. Court date is March 12, 2025. Pre-trial in front of Judge Ramsey Heath. Ms. Peters, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. There's a right to an attorney. Have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. You understand those rights, ma'am?
Yes, ma'am.
Okay, Ms. Peters, let's go with the criminal matter. Case number is 250-55-83201. Please say your full name again, ma'am.
Angelica Arthea Peters.
Thank you, ma'am. You have a defense counsel. Go ahead, counsel.
Lorraine, on behalf of Ms. Peters, waive the reading stamp mute. She's been advised of her rights.
Thank you. I'm going to enter plea of not guilty. Court dates are February 21st, 2025. It's a probable cause conference, followed by preliminary examination, February 27, 2025. Both matters are in front of Judge Jefferson. Understand those court dates, ma'am?
Yes, ma'am.
Okay, so let's start off. There's no driving of any automobiles, motorcycles, mini bikes. Let's see what else. No assaulting or combative behavior on your part. You understand those bond conditions, ma'am?
You said no salty?
No assaultive. I'm sorry if I didn't say clearly. No assaultive or combative behavior. You
I don't
understand that?
Can you explain that to me,
Sure.
please, so I can have a better understanding?
Sure. Assaultive, combative, if somebody's speaking to you, okay, it's like you start getting into a fighting stance. You want to intimidate, you want to argue, you want to fight somebody. I mean,
Understood.
you control your emotions, you control your anger. Do you understand that?
Yes, ma'am.
Okay, so that if I say something to you, you don't like, okay, that doesn't mean that you have to get in that you want to beat me up. Just because you don't like that, or if you said something to me, I can't just let my emotions take control over me and I want to beat you up. if I want to start pushing you around. No assaultive or combative behavior. Do you understand that, ma'am?
Understood.
Okay. Council Coyle, this happened February 10, 2025. Go ahead, as to bond recommendation.
Your Honor, I do see a criminal history for Ms. Peters or capious history. No objection. You've covered them in your conditions. No objection to a 20,000 personal.
No objection, Judge.
Okay, so Ms. Peters, you're gonna get a $20,000 personal bond, meaning nobody has to pay any money for you to get out of jail. Please go to court, handle your matter.
No problem,
Okay.
thank you.
Thank you. You
No
can step
problem.
aside. Thank you,
Thank
ma'am.
you very much.
Sonia, just let you know, I'm keeping this because I have to sign them. Okay, as soon as I finish this last one, I'll finish them up. What's your name, ma'am?
Megan Nicole Websey.
Say that again, please.
Megan Nicole Websey.
Thank you, ma'am. I'm Magistrate Chuck Bear. You're hearing a criminal matter, case number 240-5529-001. You have an attorney. Go ahead, counsel.
Lil Reagan, on behalf of Ms. Lopsy, Your Honor, waive the reading, stand mute. She has been advised of her rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 21st, 2025, probable cause conference, followed by preliminary examination, February 27th, 2025. Both matters are in front of Judge Jefferson. Ma'am, while this case is pending, you're not to possess or use any illegal controlled substances. You understand that?
Yes, ma'am.
Okay, Counsel Vincent, this is from 2021. Bond recommendation, please.
Yeah, we're not going to be objecting to a personal bond at this time. Thank you, Magistrate.
Thank you. Okay, ma'am, you're gonna get a $10,000 personal bond. That's what your attorney, Counsel Reagan, would argue for. And so that means nobody has to pay any money for you to get out of jail. You understand that, ma'am?
Yes, ma'am.
Just go to court, handle your matter. Good luck.
Thank you so much. Have a great day.
Thank you, Judge.
DDC, thank you very much. I believe we have everything.
Thank you, Judge.
Thank you.
Have a good evening.
Great day. Be safe.
Have a good evening, folks.
Magistrate, one heck of a day. Thank you.
Thank you. Have a good day.
Thank you. Everybody have a good day. Thank you.
Thank you.